Adjournment request, if any, from item number 1 to 6. From item number 7 to 14. From item number 16 to 27.
May I please, Lordship, I beg to mention item number 27, Lordship. Lordship, the Angus Council is out of session, Lordship. Lordship, kindly adjourn the matter after 1 week, Lordship. 1 week, Lordship.
Yes.
Please, Lordship.
No, please, Your Lordship. Lordship, I beg to mention item 21. Yes, Your Lordship. So, Lordship, we have the instruction to withdraw this PIL, Your Lordship.
That is in relation to that highway
Cyclone Raymond.
alignment of highway.
No, Your Lordship. This PIL pertains to the people affected by the cyclone Raymond, Your Lordship.
That in this February or March.
Yes, Your Lordship.
Want to withdraw.
Yes.
This is
Deeply obliged.
on instruction. Yes.
From item number 28 to 36.
Father, may I mention item number 33? Very concerned. After a week, madam. Some instructions required this file. Just on the reopening. I pray for injecting.
After a week.
Right.
May I please, Your Lordship? I would like to mention item number 35.
Yeah.
4 weeks' time may be given, Lordship, for filing the reply
By on behalf of
on behalf of A. Chakraborty.
on behalf of
A. Chakraborty, Lipika Das, L. Das.
health branch. Regarding validity of some provision is under challenge.
Lordship. Obliged.
May I please, Your Lordship? I beg to mention item number 29 to 31.
Yeah.
29 to 31, respondent number 3, Mr. NJ Gogoi, he is unwell.
These matters are to be heard finally. We will admit them and place it in the due course.
Just for the day.
We'll place it in the due course after admitting it because the matter is pertaining to year 2020. And the matter is pending. We'll admit them and then hear the matter.
From item number 37 to 41.
My pleasure, Lordship. Lordship, with the concern from other side, I beg to mention item number 40, Lordship. So, matter may be adjourned for today, Lordship. I'm for respondent number 4 to 8. 4 to, sorry, 4, 5, 6, 4, 5, 6, 7.
What do you want?
For adjournment for today.
Yeah, adjournment, adjourn.
Obliged, Lordship.
Any other request?
May I please, Lordship? I beg to mention for listing of a case tomorrow for withdrawal.
Draw.
Obliged.
May I please, Your Lordship? I beg to mention an IA for listening, Lordship. It pertains to condonation of delay for filing a writ.
Yes, sir. Daily list for orders item 1.
Violation of Barnes Kumar, my lord. That notice goes, my lord.
Notice. Notice.
My lord.
Notice. Returnable of 6 weeks.
Developed.
Item number 2.
May please, Lordship.
Yes.
My lord, as per the office note dated 7/9/24, service is yet to be received, my lord. No service report is yet to be received.
But this is 26
7.
July.
Yes, my lord.
Take fresh steps.
Yes, my lord.
Are awaited since long. When it comes for the appellant is directed to take fresh steps for service of notice upon the respondent number 4 to 18 and 20 to 28. Returnable who registered 80 and the returnable after 6 weeks.
Bye.
Item 3.
Wait, please, Your Honor.
Yes,
Leader unserved notices has been received in respect to respondent number 8.
yeah. What about you have to take fresh steps or will
On respondent number 8 is the only entity that your lordship directed us to take steps.
respondent number 8 is
Eight.
the
The registrar is by name, your lordship.
by name the former registrar.
Yes.
So you want his services to be waived or to be served? He has to be served.
He is to be served, your lordship. He's made a party. I'll leave it to your lordship. If your lordship waives off the service, then the matter can be heard and taken up.
Waived after service, so at your risk. Will waive the service of the notice upon the respondent number 8 at your risk.
A certain malafide has been alleged against the respondent, so we need to wait, your
If
lordship.
you want to press those malifieds, then he has to be there as a respondent.
We'll take fresh steps.
Okay. Notice issued to the respondent number. Notices of the respondent number 8 are awaited since long. Then the concept of the appellant is directed to take fresh steps for service of notice upon the respondent number 8 to register AT and within a period of week. On doing the same, let notices be issued to the respondent number 8 returnable 6 weeks thereafter.
Great.
Item 4.
May please, your lordship.
Who is the respondent number 3? Notices of the respondent number 3 has not been served.
Item number 4, notice is to go, lordship.
Yeah?
Uh,
Is
Consent
item
case
number
4. It has come up for the first
for the
time.
contempt case, yeah.
Yes.
Issue notice returnable 4 weeks registered AT testing.
May please, your lordship.
Item 5.
May it please the Lord, my lord, fish note dated 23/9/24.
Respondent number 8 has not been served. Respondent number 3, he has not been served, sir.
We'll take fresh steps then now.
Notice issued to the respondent number 3 are still awaited. And the concept for the applicant is directed to take fresh step for service of notice upon the respondent number 3 within a period of on doing the same, that notice issued to the respondent number 8 returnable on so and so.
But I am for the respondent number 2.
Six.
Item 6.
That legal. And so far official, and so far official data,
Respondent number 6 is not being served.
my lord. In fact, he is the formal party headmaster of the school,
A former party.
formal party lordship. In fact, he has no role.
So, what do you want?
Private respondent number 7 is the main person, lordship.
Headmaster,
Headmaster is respondent number 6.
respondent number 6, so whether he is required to be served or not.
My lord, he is not necessary lordship because he is just a formal party lordship. He has nothing to say.
Okay, the notices issued to the respondent number 6 has not been served till date. The concept of the applicant has submitted that the respondent number 6 is the formal party and therefore service of notice upon be waived. Full stop. In view of the submissions made by the concept of the applicant, service of notice upon the respondent number 6 is waived at the risk of the applicants. Yes, who is appearing for other respondents?
Department
Education Department.
Yes, who is appealing for the other respondents? Mr. A. Das, standing counsel for Education Department, put in appearance on behalf of respondent number 1, 2, 3, and 4. Where is Mr. A. Das? What about the other respondents? This is a year for orders after a week.
Ablash.
Item 7.
May it please your lordship, my lord, the IA is for the delay of 22 days.
Who is for the respondent number 8? Somebody has filed local sama.
Yes, fine.
I'm for the respondent number 8, Lordship. Do we need time to file our objection? Lord?
And how many days delay is there?
22 days.
22 days. What objection? What's the objection?
My senior instructor.
Thing. Yeah. As per the office report, notice upon the respondent number 8 has been duly served. Notice upon the respondent number 8 has been duly served. Other respondents have already been served. Services therefore complete. This IA is filed on behalf of the applicant with a prayer to condone the delay of 22 days in filing the connected appeal. Full stop. Having gone through the IA and after going through and after hearing the concept for the parties, we deem it appropriate to condone the delay of 22 days in filing the connected appeal. Hence, the IA number 22 is allowed. Delay of 22 days is condoned. Registry is directed to register the connected appeal and listed for admission after the.
Oblash.
Item 8.
After the interim order, my lord. Go ahead. Should we join the my Vamsa, my lord, in place of.
The matter comes for consideration of the application preferred on behalf of the applicant with the prayer to. Use her maiden surname, my Bansa, in writ petition being writ petition number 392/2024 instead of her husband's surname, Ojai. Stop. Having, do you have any objection? No, but. Having concept for the applicant has no objection if the prayer made in the IA number 2 is allowed. Having heard the concept of the parties and after going through the contents of the IA number 2, the application is allowed. The petitioner applicant is directed to use her maiden surname, my Bangsa, in writ petition being number 2 instead of her husband's surname, Ojai. Amended cost title in the writ petition be filed within a period of 1 week. 1 week. Registry is directed to make necessary correction in the cost title of the writ petition.
Item 9.
IA number 2 is disposed of. Notice renewable of the floor. It's 9 to 13, all issue notice, returnable, in some of the matters, returnable 6 weeks, 8 weeks, it's a different. Yes. Okay.
For admission, item 14.
Item number 9 to 13, we have already issued notices to the respondents. All are these IA applications. Item number 9 to 13, we have ordered for issuance of notices.
Yes, madam. Madam, actually, I have filed a condemnation of petition, madam.
And we have already issued
Yes, yes.
notices on those applications.
Highly obliged.
Item 14.
Well, this is a PIL for construction of a road from Bokakhat to Numaligarh, bypassing the Bokakhat town. Madam. But there was a meeting.
Similar PIL is already pending.
Yes.
In which Learning Council has time to furnish better particulars. And after going through the PIL, we are of the view that no case is made out for changing the alignment of the four-lane highway. It is the matter between the National Highway authorities and it is under their domain only. Simply because some of the villagers want that this highway should be should pass through the Bokaghat town. That doesn't mean, sir. And what is the idea of this four-lane highway passing through the city?
Well, there is possibility because the road can be widened
It will be how
and it will be shortest, my lord, because
when the time in the future the road is required to be the national highway passing from the town. It's a strange thing.
no, my lord, it is
The
not.
heavy vehicle movement of the heavy vehicle and many things are there. How can we direct them to pass construct the highway from the town?
Whatever, this is the existing national highway. It is only
Whatever existing, that's why only they are creating a bypass for that. And nowadays, this is the only way. In
Well,
every
where-
city, in everywhere, they
Well, in
are
the-
by constructing a bypass for that reason.
my lord, in our case, there is every possibility for widening the existing national highway.
Simply because that is the ultimately that is the job of the experts, and if they have opined it that the bypass is to be passed from not from the town, we are not supposed to interfere in the cases of alignment. The Supreme Court in so many judgments have specifically said in cases of highway alignment, it is the National Highway Authority only which is the authority, and no other, no order can be passed while exercising this Article 226. Power under Article 226 to change the highway. Very clear.
My lord, this is a demand of the public, my lord. There was a
Demand of the public, tomorrow the public will demand that every highway should touch my residence, whether it can be met.
it is a small portion, my lord. The road can be widened. Okay.
Because the people are demanding that, that can't be. Simply because some of the people are agitating. This can't be the reason to interfere in the alignment of the highways. It is purely within the domain of the NHAI. If they have decided to construct a highway for a particular after detailed project report and after a decision taken by the expert is not like, is there any statutory violation? Is there any malice?
No, we were asked to submit our objection and we have filed our
Yeah,
objection.
objection we have read there.
But that objection is not yet disposed of.
No, the objections, since they have already issued the notification under section 3D, that objections are deemed to be disposed of. Can't be.
That cannot be deemed to be disposed of because we are not heard.
So we are not convinced. If you want to commit something else, we can give you a date, but we are not convinced. Because
But
whatever
the-
the reasons you have supplied, though you have supplied 16 reasons, but none of the reason is convincing that we can ask the or direct the government to change the alignment of the highway. And it's very strange thing, first of all, you are demanding the highway should be passed through the city.
See, it is only
Bypass should not be constructed and the highway should, the highway should be widened in the city itself. The thousands of houses would be demolished for that purpose.
Only 2 kilometers, my lord, I have stated in
2 kilometers is 2 kilometers. If a town 2 kilometers, how many houses are there? People must have their commercial establishments. Everything would go. What would be the cost of that? It's a very strange demand. Get the highway constructed in between the city.
It is only two,
Nowhere such demand is there.
but there are so many other things, my lord. If it is go by outside the town, there is a elephant corridor, there is a
They
stream.
take care of that. They will take care of that. It's not like that. They must have considered all those things and thereafter they have planned for construction of the highway. And in those infrastructure structures, the Supreme Court has specifically said that only authority is the National Highway Authority. And the courts have no expertise to do that.
The notice of country. Well, the notice may be issued there.
For what, sir? At least we should be convinced for issuing of the notices. Right?
My lord, the page 57, my lord, you have stated.
Yeah.
The distance between the proposed bypass point to Latabari to Bokaghat are 2 kilometers.
Page 57.
Page 57.
Yeah. The distance to be greatly reduced, it would result in less activity. So that is, if they are spending much money on construction of the bypass, what is the problem with that? They construct a bypass always. This is the idea. The highway, national highway should not be passed through a city. It is always bypass. It will reduce the travel time. It will reduce the traffic congestion. Accidents will be ignored and nothing. Avoided. Accidents can be avoided.
My lord, it may be then, my lord, it may be taken up on some other day. I shall satisfy you.
Another petition is there for the similar demand. Do you aware of that?
Yes,
So why this second PIL? What PIL?
that is for another bypass.
The same bypass, Buka Ghat, so far I remember. Same bypass that it should be constructed through town Buka Ghat.
No, our is Bokaghat to Numaligarh.
Numaligarh area or something, yes. Okay. This PIL petition is filed by the petitioners. Being agreed with the decision of the respondent authorities in granting their approval to new alignment bypassing Buka Ghat town for extension of National Highway 715 in bracket old National Highway 37 bracket closed into a 4-lane highway from Kaliabor Tinali in the district of Nagaon to Numaligarh in the district of Golaghat via new alignment instead of existing NH 715 alignment through Bokaghat town. Full stop. The petitioners have also prayed for quashing and setting aside the notification dated 12/2/2024 issued by the Ministry of Road, Transport and Highways under Section 3, Capital A of National Highways Act 1956. Is and further ancillary prayers have also been made. Full stop. From the perusal of the petition, it appears that the petitioners are demanding to change the alignment of the National Highway 715, which has been approved by the respondent authorities and specifically made a prayer to construct or widen the National Highway 715 without bypassing the Boka Ghat town. Full stop. Para. Prima facie, we are of the view that the grounds on which the petitioners have made the above prayers are not convincing. Otherwise, also, the Honorable Supreme Court in Union of India versus Kushala Shetty and others reported in 2011, when 2011 12 SCC 69 has categorically held that the projects involving construction of new highways and widening and development of existing highways are purely within the domain of the experts. And NHAI is a professionally managed statutory body, is only authority to approve such projects. Full stop. At this stage, the concept for the petitioner takes some time to convince this court regarding the maintainability of this PIL petition. Time paid for is granted. It's not 8 weeks.
Item 15.
May it please the Lord. Now, if your lordships would kindly come to the rules, my lord,
Yes.
at 142. And the relevant portion is at page 145.
Yes.
Please come to 3, my lord, 3, somewhere in the middle of that page. 5, 3. 5, it starts at page 144. And if your lordships would kindly come to sub-rule 3 at page 145.
Recruitment to the
Recruitment to the cadre of sericulture demonstrators shall be made 100% directly from candidates who passed HSLC examination and also completed 1-year certificate training course in sericulture from Sericultural Training Institute till 96-97 batch and higher secondary science examination passed or equivalent and also completed 1-year certificate training course in sericulture from Sericultural Training Institute Titapur from 97-98 batch onwards. Now, my lord,
You're right. That the rules doesn't say about this written examination.
Yes.
But there is no prohibition for conducting the written examination too.
no, my lord, all
Only
throughout, no, my lord,
merit-
all,
By preparing the merit or comparative merit.
Yeah.
Yes, earlier they have adopted this. But
no,
it now.
all throughout, my lord, till there,
Yeah.
They have only done through the Milord. Whosoever has completed the training, based on seniority, they are being given. And that is
basis
the,
of the merit.
yes.
On the
And
basis-
we have annexed all the previous advertisements also.
That's right, sir, but where is the prohibition?
No, my lord.
That they can't conduct
my
a
lord.
written test for.
No, my lord, since there is a 309 rules, when 309 rule prescribes a particular procedure.
That's right. But in the 309 rules, there is no, nowhere provides that the selection should be on the basis of the merit of the candidates. They
my
only
lord.
says that this is the requisite qualification.
Huh.
And now if they have decided to have the written
No, my lord.
examination for that, how you are going?
No, my lord, question is, my lord, all throughout it has been done this way, my lord. Now, at this-
Your only grievance is that you can't compete with the young candidates. That's the only genuine grievance, which genuine or maybe as per you, that genuine grievance is there. But once you are granted this age relaxation, then you have to compete with the others. Age relaxation.
No, age relaxation is not an issue now.
Now, the court has directed them and they have
They have
granted the age
considered.
relaxation.
No, my lord, the learned single judge relied upon Leeladhar and all these cases. My lord, with all respect, I'll submit, my lord, what had happened. In Ajay Hasia, Lordship would recollect in 81, Ajay Hasia was a case pertaining to admission to educational institution. That 15% was prescribed therein. In Leeladhar, that was distinguished, saying Leeladhar dealt with an issue, recruitment to public service. And Ajay Hasia was, admission to educational institution. Therefore, in Leeladhar, Honorable Supreme Court has said that when it comes to, my lord, recruitment, 100% it could be on the basis of interview also. In fact, the learned single judge has relied upon the judgment which runs contrary to the view of the learned single judge. Until Milad Anjar Ahmed's case, Honorable Supreme Court says when it comes to recruitment to public service, it could be 100% by interview.
But the learned single judge is relied on those judgments only to in support of. his
Buttress the
view.
point that written
That written examination is the better.
also could be a possible. No, in a given case, yes. In a given case, yes. But when, my lord, the rule itself prescribes a particular procedure, then to introduce a written examination.
No problem, because the rule nowhere says that it should be only on the basis of merit. And there is no prohibition for conducting written
No,
examination.
my lord, rule does not envisage a written examination. That is our case.
The rule also doesn't say that it should be by merit only. So then the state government has decided that.
No, my lord, there is a lot of heartburning in the, service. Thus will kindly appreciate all throughout it was on the basis of the rule. Now, how can they change that rule, my lord, to our prejudice? Had it been a case where rule
Examinations have already been held or what?
my lord,
Written examinations?
no, they have not proceeded because of the pendency of the writ bill. They have not proceeded with the matter.
There is no stay. Why you are not?
No, reason is, my lord, I have just now asked my learned friend whether the selection has been held or not. My learned friend says the instruction is, my lord, the department will have to pay. SEBA is the authority who will selecting agency, my lord. We have to make payment to SEBA. Once we make the payment, and if there is some order here and there, my lord, unless it is decided, there is difficulty in getting back the money. So there is a lot of expenditure involved. My lord, lordship,
How many petitioners are there?
Once, my lord. 79, I think, my lord.
Appear at the written examination.
my lord, lordship, before that, lordship, kindly have a look at
Or 31, my lord.
Rule 6, my lord.
31.
31 only.
My lord, Rule 6 provide for selection.
Yeah.
Lordship may kindly turn to page 146. The rule which my learned friend has read is the rule which provide for eligibility. Now, eligible persons, how is they have to be recruited, selected by law? Recruitment is page 146, Rule 6, my lord. Subject to Subrule 3 and 4 of Subrule 13, direct recruitment shall be made on the basis of selection made by the committee or the commission as the case may be, in accordance with procedure hereinafter provided. Before the end of each year, the appointing authority shall make an assessment regarding the likely number of vacancies to be filled up by direct recruitment during the next year and shall intimate the same to the committee or the commission as the case may be, together with details about reservation for candidates belonging to scheduled caste and scheduled tribe or any other category as laid on by the government as provided under Rule 15. The appointing authority shall simultaneously request the committee or the commission as the case may be to furnish a list of candidates for direct recruitment in order of preference. The committee or the commission as the case may be shall make selection in accordance with the procedure prescribed by the government. The committee or the commission as the case may be may hold such test or interview as may be considered necessary. D. The committee or the commission as the case may be shall furnish to the appointing authority a list of candidates containing names equal to the number of vacant posts notified at the time of calling for applications for filling up the post in order of preference found suitable for direct recruitment. Now, the Honorable Single Judge has taken note of another thing, my lord. Lordship, may kindly see page 213.
Yes,
Para 9 and 10, my lord.
yes.
Para 9 reads, by drawing the attention of this court to the affidavit in opposition filed on 2/2/24 in WBC number so and so, the learned state council has referred to the averments made in paragraph 4. It is averred that earlier appointment procedure was not done in a scientific manner and there was no specific procedure to examine the competence of the candidates. It is also stated that in the training institute, only certain skills are imparted which will not do away with the requirement to compete in an open competition selection. The learned state council has also highlighted the aspect that the employer should be given the prerogative to adopt the most suitable method to select the best candidate out of the lot, and an introduction of a written test cannot be argued to be unreasonable or arbitrary. He submits that such introduction, on the contrary, would enhance the public trust in the recruitment process as it would rule out any apprehension of bias or favoritism in a process where recruitment is done only by interview. Then, my lord, para 16 at page 214 is the finding starts, my lord. Para 16 at page 214, man. Marks obtained in the training course cannot be directly related with a recruitment process for the post in question. A recruitment is done by making a selection of the suitable candidates who apply for the said post on the basis of such method adopted. Adopting the requirement of having a written test cannot, by any stretch of imagination, be held to be arbitrary or unreasonable. Rather, in the opinion of this court, that will add to the aspect of maintaining a fair and transparent mode of selection. This court has been apprised that while the total number of posts advertised is 140, the aspirants are about 260, which include the petitioners. The aspect of being overaged has already been addressed by this court, and the applications of the petitioners have been accepted. There is no reason as to why the petitioners would not be required to participate in the selection in which a written test is envisaged. It is settled position of law that for a public employment, open competition is a precondition. While such competition is to be held by means of selection, it should be the prerogative of the employer as to how a selection is to be made, which can be done by conducting a written test. It is only when the method adopted, which is violative of any statute or any malafide, is able to be demonstrated, the court would interfere. Otherwise, the court would be loath to interfere with the selection process. In the case of Leeladhar Supra, the Honorable Supreme Court was insisting of the aspect of and this rule itself provides for selection, my lord, as the Lordship is stating, Rule 6, my lord. Test and selection, interview.
Yes,
My lord, if your lordship will kindly have the Leeladhar judgment, my lord, because Leeladhar is the sole basis of the learned single judge's view.
learned single judges.
My lord,
Why? In para number is 16.
Yeah.
is first opened and then taken the aid of this Leela. Otherwise, the learned single judge is already open.
No, my lord.
Adopting the requirement of having it cannot be by stretch of any held to be arbitrary and reasonable. Rather, in the opinion of her, this will add to the aspect of maintaining fair and transparent mode of selection. This court has apprised that while the total number of posts so and so, so and so, so and so, there is no reason to why the petitioner would not be required to participate in which the written as
Like this view of the learned single judge is not wrong. But in the context of the rule, whether this view was at all required, my lord, that's the only issue. But like in an appropriate case, the view of the learned single judge is absolutely correct. Because written test brings in more, my lord, objectivity. There's no doubt about it. I'm not saying that. But the problem is, my lord, the rule does not specify a written test. Rule says based on the performance in the set training. That's why we are before your lordship, my lord. My lord, that's why I was trying to place before your lordship Leeladhar's judgment. In Leeladhar, Lord, I was trying to draw your lordship's kind attention to Leeladhar. If your lordship would kindly come to page 164, para 6. Because mass stress was laid on Ajahasia's case, therefore, my lord, Leeladhar carves out the exception.
Yes.
Para 6. Thus, written examination assesses the man's intellect and interview tests the man himself and the train shall meet for a proper selection. If both written examination and interview tests are to be essential feature of a proper selection, the question may arise as to the weight to be attached respectively to them. In the case of admission to a college, for instance, where candidates' personality is yet to develop, and it is too early to identify the personal qualities for which greater importance may have to be attached in later life, greater weight has perforce to be given to the performance in the written examination. The importance to be attached to the interview test must be minimal. That was what was decided by this court in so and so and so and so and other cases. On the other hand, in cases of service to which recruitment has necessarily to be made from person of mature personality, interview test may be the only way, subject to basic and essential academic and professional requirement being satisfied. To subject such person to written examination may yield unfruitful and negative result, apart from its being an act of cruelty to those persons. How can this judgment come to the rescue of the state, my lord? That's why I said the judgment helps our case. Huh? বুঝিয়ে পাও নাই please. Written examination to justify কৰিবৰ কাৰণে সঞ্জয় এইটো লগাই দিছে। It runs counter.
Yes.
So therefore, my humble submission is, my lord, Leeladhar is an authority for the proposition that in case of admission to educational institution, written test should normally be insisted upon because at a young tender age, the mental faculty does not grow. But when it comes to recruitment to public service, that is older persons, my lord, if they are to be subjected to written examination, then it will be a nullity. On the contrary, my lord, now there is no prescription in the rule. So therefore, my humble submission is, my lord, the learned single judge has committed a serious error in relying upon Leeladhar for the proposition my lord, learned single judge was trying to justify why written examination would serve the purpose, for which Leeladhar could not have been the proposition. On the contrary, Leeladhar runs counters to the view taken by the learned single judge. Therefore, my humble submission is, my lord, let them conduct the test as they are doing presently. And my lord, I'll rely on one more authority.
Yeah.
That is, my lord, 1992 Supplementary 1 SCC 584. That is the past practice.
1992.
Supplementary 1 SCC 584. When court will, my lord, approve the past practice in a department.
Yeah.
Please come to page 586, para 4.
Yes.
In our opinion, this appeal has to be allowed. There is sufficient material, including the admission of respondent diploma holders, that practice followed in the department for a long time was that in the case of diploma holder junior engineer who obtained degree during service, period of 3 years service in the grade for eligibility for promotion as degree holder commenced from the date of obtaining of the degree, and the earlier period of service as diploma holder was not counted for this purpose. This earlier practice is clearly admitted by the respondent diploma holders in para 5 of their application made to the tribunal at page 115 of the paper book. This also appears to be the view of the Union Public Service Commission contained in the letter dated December 6, 1968, extracted at pages so and so of the paper book in counter affidavit of the respondent number 1 to 3. The real question, therefore, is whether construction made of this provision in the rule on which past practice extending over a long period is untenable to requiring upsetting it. If the past practice is based on one of the possible construction which can be made of the rules, then upsetting the same now would not be appropriate. It is in this perspective that the question raised has to be determined. So, my lord, if there is a past practice in the department and the past practice is consistent with the rules, then, my lord, it should not be upset. In our case, my lord, there is no prescription in the rule. And that's my humble submission, my lord.
Yes.
I'm just pointing out once again, my lord, rule 6 C and D are very clear. It page 147, it says, my lord, that commission or the selection agency, my lord, as the case may be, may hold such test or interview as the case may be considered necessary. So that itself is very clear. Rule itself provides for selection and test. In the face of these rules, my lord, the submission that past practice was there will not hold good. This is my humble submission. And secondly, my lord, in the judgment of Ashok Kumar Yadav, quoted paragraph 15, quoted in the judgment of the learned skill, my lord, page 216 and 217. In the second paragraph, my lord, the object of holding written test as well as viva voce has been clearly, my lord, stated by the Honorable Supreme Court. That your lord will kindly note. My lord. And when the rules are very clear that selection test and interview is to be held for the purpose of assessing the suitability of a candidate, my lord, then other things will, my lord, not prevail.
Close for orders.
My lord.
Different.
Problem.
Item 16.
Yes, sir.
May I please, your lordship? Lord, this case, this appeal is against the impugned judgment and order dated 22/12/2023 in WBC number so and so. Your lordship will page 38 annexure 13 year.
Page 38 annexure.
Annexure 13 year.
Yes.
The Honorable Singhul, your lordship straightway dismiss the writ petition, your lordship, without hearing the petitioner, appellant, your lordship.
Hearing the petition.
My lord, just straightway, your lordship dismiss the writ
Or
petition.
Mr. R.L. Chaudhary.
My lord.
It is written in the order itself.
Not showing it, but my pleadings were not considered and
So what are your pleadings?
my lord. My lord, the father of the appellant was expired on 19/4/2009, your lordship.
19/4/2009.
9, your lordship.
Okay.
As per death certificate, your lordship, file annexure 9, page 23, your lordship.
Fine.
Page 23, your lordship.
Yes, 2009.
My lord.
It is not disputed by the Leonard single judge also.
My lord.
Father died on
2009.
19/4/2009.
9, my lord.
And he moved an application for seeking compassionate appointment.
2014, your lordship.
Huh?
2013, your lordship.
2013.
13 years old. Due to
And
some, they had a
he attained majority in the year.
majority, my lord, in the year as per honorable court,
Honorable court ne as per you.
my lord. But date of death, you will, date of birth, you will lordship.
Is 83. And as per them, he attained the majority in the year 2001.
My lord. Main condition is you will lordship.
And after attaining the majority in 2001, after 12 years, he has applied for compassionate appointment. Where is the provision says that only within 2 years you can apply for.
That is when the date is, it is depend upon the date. It's a compassionate ground appointment.
Maybe.
Compassionate
That's
date.
why only
After that, he will be competent to apply, your lordship.
Oh.
Not prior to that, your lordship. Not prior to that. Though he may be in
On the-
18
on the-
years,
on the
18,
On the day when your father died,
my lord.
he was already a major person.
Major, man.
After 4 years, he has applied. for
After
com-
4 years, that is
Why?
the main condition.
Why?
4 years delay, they are not aware regarding the notification, your lordship. That is why, your lordship.
Who was not available?
These are the laymen, your lordship.
Is this, this excuse can be accepted? That any person is not aware about the rules or notifications or, this is a valid excuse. This is a valid excuse.
Your lordship may consider, yes, because these are the laymen, the rural areas, your lordship. They are the not even no regarding the notification, your lordship.
Another question
That is why even
okay,
he approached the authority orally, your earlier, your lordship.
in
But
the year
subsequent
2013 for the first time.
but black and white, your lordship. As per the selection statement, your lordship.
So a person is required to move an application within how much time? Within which time limit?
There is regarding 1 year, your lordship.
1 year.
1 year.
After the-
Normally 1 year, your
after
lordship.
the death of the government employee is dependent, is supposed to file an application within 1 year.
Application is 1 year, but there are some conditions, your lordship, will as per notification, your lordship, page 26, your lordship. Page 26, the government notification, your lordship. Page 27, your lordship.
Yeah,
Para 6, your lordship.
yes,
Only one son and daughter, near relatives of government servant will be appointed under the scheme. Ordinarily, the scheme is applicable to only such families was have no earning members. He has no any earning members here. That father was only the sole earning members here. Regarding that condition, you also upon that condition, there may be at least my humble submission to place the matter before the DLC also. Nothing is, I don't want to give the appointment also. My humble submission.
appointment.
No,
Then
no,
why you are-
later if the
Don't
DLC,
want appointment.
no, if the DLC will consider my application, your lordship, then the matter is different,
It's a-
your lordship.
You are not in requirement of any employment just for the sake of shaking the government. You are making.
My
application.
humble
You don't want
submission-
appointment, consider my application. I don't want. appointment.
My humble submission, your lordship, will to place the matter before the DLC. Simple.
When you are not in requirement of any appointment, there is the
No,
need
no.
of placing the matter
Eh,
before the DLC.
No, no.
You
DLC may,
yourself has said, don't give me appointment,
No, no, no.
consider my application.
DLC may consider or not consider. It is up to them. They verify the documents and the papers, your lordship. Thereafter, if they consider my cases, your lordship, that is different, your lordship. So my humble submission before your lordship to give a direction to place the matter before the DLC also. Before the DLC. Simple prayer, your lordships. DLC will inquire the matter, your lordship, everything papers, your lordship. This may be your lordships. It is a compassionate appointment, your lordship.
That's why only it's.
My lord,
It's not.
it
a
is
regular
affectionate,
appointment.
affectionate, your
Only a
lordship.
Compassionate appointment.
My
is a
lord.
Scheme.
My lord,
And no person can claim as a matter of right appointment
Well.
to this scheme.
my lord. It is the discretion of the lordship. May consider to place the matter before the DLC, your lordship. My humble, small prayer, your lordship. He has no any earning members in his family, your lordship. The sole person, your lordship, surviving in this.
Okay, your father died in the year 2009,
Nine. That is correct, your lordship.
now 2024.
Now,
How
now,
is surviving till date without the government employment?
well, And they may consider as he has no any employment.
Just,
He has no any employment
how is surviving till date?
till that, my lord, by any means they are surviving in the rural areas where that by daily wages and laborers.
So.
That is
earning
why this
is-
way you will
so
achieve.
He's earning.
Earning means you will achieve that. This is that by livelihood by any means you will achieve. But
Then. if
in
he's
this,
able
in
to-
this way,
able
no
to-
any employment in the
financial-
family you will achieve.
The financial hardship which he pays on account of that of his father is already over.
That is correct, you will achieve, but
The
according to his
Leonard Singh
economic
the
economic
Leonard Singh
condition.
Has not dismissed your petition while on this aspect also. But we don't have.
Due to the economic condition, you will achieve I have stated the ground you will achieve. You will achieve well fine. Page, my ground number 2 you will achieve. Ground number 2.
Yes.
Further, the single judges fail to appreciate the facts and eligibility criteria for appointment on compassionate ground due to the economic condition of the appellant petitioner. And moreover, ground number 3, you also further the learned single judge has not given the reasonable opportunity to defend the case of the appellant petitioner by dismissing the writ petition, nipping the body. So then the third, straight way you will achieve dismiss the writ petition, you will achieve. Then another ground, you will use ground number 5, further the respondent authorities have not placed the application of the petitioner before the DLC. As no any employment in the family of the appellant petitioner in these hard days, even after also several schemes are issued by the respondent authorities. Simple prayer you will achieve, direction will be given to place the matter before the DLC.
Any other argument?
No, madam, this is my.
Now your grievance that the Leonard single judge has not heard you, that is redressed. We have heard you. These are the arguments.
Heard you know, Chief, that elaborately, just at least notice may be issued at that time, and without issuing the notice. If notice was not given, how the pleadings will be,
Let this,
my lord, at least notice may be issued in this.
should we leave to us whether notice are to be issued or not?
My lord, all heard the matter, both sides, your lordship. The government has not given the notice, your lordship. That is.
We don't expect that the government is required to file any reply in this. We are not at all convinced.
My humble submission, you will achieve at least place the matter, direction will you going to place the matter before the DLC.
Only in appropriate, this is not in everything. Okay.
This is a.
That's all.
Well.
This writ appeal is filed by the appellant being agreed with the order dated 22/12/2023 passed by the Leonard Single Judge in the petition number 7501 of 2023. The appellant has approached the writ court with a prayer to issue a direction to the respondents to place the application of the petitioner before the DLC for proposal of the appellant petition, for proposal of the appellant, for proposal of the name of the appellant, for providing appointment on compassionate ground on the post of assistant teacher and any other equivalent post. Full stop. The learned single judge has dismissed the writ petition filed on behalf of the appellant while observing that the father of the petitioner, who was working as assistant teacher with the government, died in harness on 19/4/2009, whereas the application for compassionate appointment was made by the appellant only on 9/7/2013. That is much after the time frame prescribed in the scheme holding the field. Full stop. The concept of the appellant has submitted that the appellant has failed to move an application within prescribed time, as he was not aware about the said time limit. It is also submitted that the appellant and his family was solely dependent upon his father, who died in harness while working with the government, and therefore the learned single judge should have issued a direction to the respondents to place the application filed by him before the DLC for consideration of providing appointment to the appellant on compassionate ground. Full stop. Having heard the learned counsel for the appellant and after going through the material available on record, we are of the view that the learned single judge has not committed any illegality in dismissing the writ petition, while taking into consideration the fact that the appellant has not filed the application within the time prescribed in the scheme for compassionate appointment. Full stop. Otherwise also, the appellant is also not entitled for appointment on compassionate ground because his father, compassionate ground, as his father died while in government service in the year 2009, and till date, the 2009, almost 15 years have passed, and the appellant and his family is being survived without the government job. And as such, in view of the decision of the Honorable Supreme Court rendered in Devashish Tiwari, and give the supply, Devashish Tiwari, the application, the prayer of the petitioner for providing him compassionate appointment is not liable to be considered. With these observations, the writ appeal dismissed. On one more additional ground. Dismissed on one additional ground, along with the ground which has been considered by the learned single judge, we have also supplied additional.
Item 17.
May I please proceed? Consider certain position of law that on the basis of conviction, a person can be terminated from service. Now that action was contemplated by the department. Now afterward, my lord, the conviction order was put under challenge before this honorable court, and this order was interfered with by.
That was set aside.
Yes, set aside. Now afterward, my lord, approach before this honorable court for reinstatement and other service benefit. Now, lordship, while this matter was taken care of, the learned single has granted multiple relief to the respondent concerned. Page 68, my lord.
Yeah.
Now kindly see first pair, page 68, paragraph 38, my lord.
The period of suspension of the original petitioner.
Yes, my lord.
This
This,
is retirement in services.
This never was the pleaded case of the petitioner because there are two segments of suspension and reinstatement. First, in 1999, it was suspended. 2002, it was reinstated. But my lord, on the basis of conviction 2008, my lord, afterward action was contemplated. This relief, my lord, nowhere pleaded in the writ petition. Lordship, can you see page 24 for a moment of the prayer part?
Yes, sir.
Page 24. Neither we have advanced any submission on this point, and never it was the ground of the writ petition, my lord. No relief was sought for even.
No, it's Okay. The issue of this. In the meantime. Effect and operation of the order dated. 30th of July, 31st of July 2024, passed the petition number 5/88/2016 shall remain in state. Returnable A3.
Deeply obliged.
Item 18.
Mayor Kalisi. Your Lordship, the issue, one of the issue involved is that when a coordinate bench has decided a legal issue, subsequent coordinate bench, if it doesn't agree with the finding, can it, should it refer it to a larger bench or should it decide it on the contrary? Your Lordship, what has happened here is with regard to, after the amendment of the Arbitration Act, Section 12(5), the Supreme Court in TRF starting said that the authority who is not eligible to appoint an arbitrator, he also, being not eligible to, being an arbitrator, he is also not eligible to appoint an arbitrator. One of the decisions, central organization, considering clause 64 of the GCC of railway, says that in terms of that clause, the railway general manager can appoint. Correctness of that decision have been referred to the larger bands. Larger bands have already heard the matter on 31st of August, headed by the Chief Justice. Judgment will come in short time. Now, in Borpeta Agro, Your Lordship, this honorable, it was held that since the correctness of the decision in central organization has been referred, therefore TRF will be binding. And applying that principle, the Honorable Single Judge appointed an arbitrator. In our case, the Honorable Single Judge has said that the central organization will continue to operate.
Obviously, the Supreme Court has said that once if a coordinate bench is differs from the earlier judgment, that doesn't mean that the judgment has lost its credibility. It has to be the Supreme Court judgment, specifically Union Territory of Ladakh.
Absolutely, but there it says the earlier judgment. So this Honorable Court has already held that TRF will be binding. In my case, I'm saying
And the learned single judge has granted you liberty.
that liberty will only
It
come
is the
provided the
basis-
Supreme Court set aside section this judgment,
Which judgment?
central organization. If you'll ultimately see the conclusion,
Just see.
conclusion is
The
that page,
communication, the relief, the learned single judge has decided that page number 26 of the judgment, para 34.
yes, Your Lordship, I'm there.
The challenge to the communication that it is rejected on the ground that the said issue is being entertained in the present petition reason so the petitioner would be at liberty to challenge the constitution of the arbitral tribunal at the stage of section 34 of 1996.
Say, it would,
However, be open for the petitioner to recourse of section 14 of the Act of 19 in terms of the judgment of the Supreme Court in so if the constitution overrules the judgment of central organization.
absolutely. But my right will only come once it is set aside. In the interim, what is happening, Your Lordship, is that the arbitral tribunal is proceeding.
You submitted before the learned, here before this court, you agreed for that. You have not objected anything. You have submitted your claim. They have also filed their, in rejoinder, you now come with the, since the Supreme Court has referred the matter to the larger than therefore this proceedings may stay.
Your Lordship, I understand but Your Lordship may consider this, that at that stage, because the law was not clear, I was not in a position to either file 14.
Then wait for the judgment and then only raise your objection. At this stage, we can't say so.
Means, because,
You have this Supreme Court judgment. you can't
but
say
considering
the
that if,
judgment is-
but if Your Lordship may just consider one aspect, if TRF, if instead of central organization, if TRF is applicable now, I can read section 14.
Either wait for this, once the judgment is already, the arguments have already been concluded, let's wait for the.
31st August, the argument was concluded, and considering the fact,
likely to be within a month.
not within a month, before 10th of November.
That's right. Within a month includes the 10th of November. Within a month, not after a month.
Can it come after that?
Let's go ahead. Let's start with 3 weeks.
Okay.
Item 19.
Me, please, your worship. Before I come to the merits of the case, the matter has been listed for the first time today, my lord, after condemnation of delay. There is, my lord, some communication from the, my lord, transport department to the, my lord, IOC, which may be, my lord, relevant for the purpose of determination of the issues in this case. So, my lord, without the leave of this honorable court, my lord, I could not have filed the, my lord, affidavit. If your lordship grants me 1 day or 2 days time, my lord, I'll find an additional affidavit.
Next week,
My lord.
with the request of the opinion list after the.
Lordship, there is a similar, actually similar VTP file on the same fact. Let it be listed with the same VTP.
Together.
Similar facts.
Same.
Same judgment.
Same judge.
I mean, similar.
Same judgment, another opinion.
Similar point, my lord,
By whom?
by the IOCL.
Along with that,
Yes.
number two. List after a week along with.
310 of 2024.
Obliged.
Item 20.
Please, my lord.
This matter was filed during session. At the outset, my lord, I want to concede that my remedy lies before the learned DRT and DRAT. But the difficulty is that, my lord, after the dismissal of my SARFACI application, I preferred an appeal before the DRAT Kolkata. Now, DRAT Kolkata is not in session since 9th of October and is only reopening on 1st of November. Now, what is happening, my lord? After the dismissal, the respondent bank is now moving aggressively, and there is a section 14 order which was passed by the learned DM, where there is an apparent and looming threat of dispossession. If my lord is pleased to see page 35. 35 is the DM's order. My lord, this particular property, there are 3 properties which I have annexed as at page 27 in my schedule. One is my residence, which I co-own with my mother, who is 93 years old. All I am saying, my lord, that let me stay protected until my DRAT appeal is taken up on merits. That is the only limited relief that I have.
Go and make a prayer before the deal, not before this court.
My lord, I have in fact taken instructions from my learned colleague. There was some attempt that was made to mention the matter before DRAT Kolkata, but right now there is no mechanism per se, and I will be remediless till 1st of November.
I think this court was for vacation, closed for vacation. What step you have taken for that? Take your steps. Show the urgency. They'll take care of that.
My lord, till 1st of November, I might be remediless. That is the reason I'm troubling my lord. There is no other reason to come before this court. Till 1st of November, let the operation of the DM order be stayed, my lord.
Place sympathy may create trouble for us in the future also. People may come, sir, tomorrow is a Saturday and Sunday, please grant me 1 day time, 2 day time. We can't do that.
But that is the reason. I completely bow down to what my lord is saying. The only problem is,
Supreme Court in so many words has deprecated this practice. Don't interfere, don't interfere, don't interfere. We are not supposed to defy that.
Hence, I'm not even troubling my lord with the merits of the matter. Although,
even though we can't go into the.
I understand, I am only on a very limited issue.
You are troubling us.
No, I'm on a very
We will
limited
not
issue.
take this trouble, sir. Even though if you try to trouble us, we will not take this trouble.
I so humbly bow down. My lord, till 1st of November, I might be remediless. That is the reason I have come.
It may be.
I might be remediless.
When this order was passed by the DRT.
By the learned DRT, that was passed on 26th of August.
August.
Yes, I filed my appeal.
And DRT, you filed the appeal before the DRT in
3rd of October.
3rd of October. Why you have waited for this more than a month?
But there was some difficulty in obtaining the certified copy. All of that is before the court.
It's an excuse.
All of-
If you are so in hurry, you should have filed the appeal within time.
one particular fact which my lord may appreciate.
DRT is closed since 9th of October.
9th of October.
9th of October to 1st of November. You have waited for this. You just tell me this order is of August. You waited for 3rd of October and then you filed the appeal. And now you are saying, sir, because the DRT is not available, therefore you interfere. We are not going to it.
No, my lord, just one particular fact for my satisfaction, my lord. Yes, I have filed it within the 45-day period. My appeal is pending.
You should
After the dismissal,
you should be vigilant that the DRAT is going to close on 9th of October. You should have filed in September itself.
my lord, there was some difficulty in obtaining the certified copy. All of that is before that court. Now, what has happened after the dismissal, they are moving aggressively for dispossession.
Actually, sir,
Yes.
ultimately they have to recover the loan.
So
We can't send them, don't move aggressively.
no, precisely. My lord, all I am saying, let me at least argue a fair case before DRAT, which will otherwise get infructuous.
Argue it out, but not a case of interference or any interim order.
Till 1st
Till
of
what
November, till 1st of
Please.
November, if my lord will protect me, only till 1st of November,
We are
I'll
not
take my chances. Before DRAT, I'll make a mention on 1st of November for a hearing. Only till such date the operation of the section 14 order be stayed. Only till
Your
such date.
Sisters will observe this, that you have not approached the DRT within time, and on the nick of the time you approach the DRT. And now you have come with this before this court that grant indulgence because the DRT is on vacation. We can't do that.
It was filed on 3rd of October. My
3rd
lord,
of October, order is 26th of August.
26th of August, but then
Why
there
you
was,
have waited for more than 1 month, sir?
my lord, the certified copy was not being provided. I have made an
Very well-
application.
You can very well approach the DRT that certified copy is not available, but hear me, this is the urgency.
But there's
You
a,
would have done it.
now in terms of the Honorable Supreme Court's order, without the certified copy, there's some impediment in the listing of the matter.
What
So
of-
that is the only reason why we are before this court today is till 1st of November.
Anything else?
My lord, at page 31, there is the resolution that was passed. This resolution was passed by the Debt Recovery Tribunal Bar Association on 24th of September.
Yeah.
So only after the approval of this resolution was this particular vacation approved, starting 9th of October till 1st of November.
Except urgent put up matters. Physical
Yes, yes.
functional sale cannot be deferred due to.
I have, in fact, I understand what is falling from this honorable court. I have taken
Sir, it is
I have
the-
taken instructions, my lord. Certain attempt was made for the listing, and right now there is no mechanism, there is no court that is available for my remedy.
Fine.
Now, I might be remediless, I repeat. My lord, till 1st November, I might be remediless, and in light of the learned DM's order, I lose my residence, the possession of my residence, which I co-owned with my mother. So that is the only reason why till 1st of November, I may be protected for me to get a fair hearing before the Honorable DRAT, Kolkata.
Okay. This petition is filed by the petitioner. Being agreed with the. With a prayer to direct the respondent bank to stay the execution and operation of section 14 notice dated 27/9/2024 under the SURFACI Act until the final disposal of the appeal filed by the petitioner and is pending before the Honorable before the Debt Recovery Appellate Tribunal, Kolkata. Full stop. In alternative, the petitioner has also claimed that a writ in the nature of certiorari be issued and the notice under section 14 issued under section 14 dated 27/9/2024. Section 14 of the Surface Act 2024 by the District Magistrate Kamrup Metropolitan Guwahati may be quashed and set aside. It is to be noticed that the application filed by the petitioner before the DRT Guwahati under section 17 has been dismissed on 26/8/2024. Full stop. Against the said dismissal, the petitioner has the remedy to approach the deprecatory appellate tribunal, and the deprecatory appellate tribunal by filing an appeal under section 18 of the Securitization Act, and the appellant and the petitioner has already availed the said remedy. Full stop. It is contended by the concept of the appellant that since the DRAT Kolkata is closed on account of puja vacation up to 1st of November 2024, this court may grant indulgence and restrain the respondent bank to take any coercive action against the petitioner till 1st of November 2024. Having heard the learned counsel for the petitioner and after going through the material available on record, we are of the view that no such indulgence can be granted by this court while exercising extraordinary jurisdiction when the statutory appeal filed by the petitioner is already pending consideration before the Deprecatory Appellate Tribunal, Kolkata. To stop, the petitioner is free to approach the DRAT Kolkata by moving appropriate application for urgent hearing of the appeal preferred by him during the puja vacation. Hence, we are not inclined to entertain this petition. The same is there dismissed.
Obliged.
Item 22.
Please, my lord.
Lord, we'll kindly look at the amended act, Lord, which is at page 40, annexure A1. And then, my lords, let's page 40, my lords, annexure A1.
Yes.
Lords, and the relevant provision, my lords, if the lordship will kindly take, that's at page 41. The last at the bottom of the page, my lords. Insertion of new section 1A. After section 1 of the Principal Act, the following sections shall be inserted, namely 1A, Act to cover certain land. The following land shall be covered under the provisions of this Act, namely the land that has been declared or notified as forest in accordance with the provisions of the Forest Act of 1927 and under any other law for the time being in force, and the land that is not covered under clause A but has been recorded in the government record. Now, let's kindly thereafter see subsection 2, which is now introduced. The following categories of land shall not be covered under the provisions of this Act, namely, now let's kindly, I would request the lordship to see subclause C. such forest land as is situated within a distance of 100 kilometers along international borders or line of control or line of actual control, as the case may be, proposed to be used for construction of strategic linear project of national importance and concerning national security. And then 2 or up to 10 hectares proposed to be used for construction of security related infrastructure, or as is proposed to be used for construction of defense related project or a camp of paramilitary forces or public utility projects as may be specified by the central government, the extent of which does not exceed 5 hectares in a left-wing extremism affected area, as may be notified by the central government. Now, my lords, the sub-clauses, your lordship will see 2 and 3, there is a physical limitation, my lords, of 10 hectares and 5 hectares. But, my lords, what we are troubled by is, my lords, the sub-clause 1, which is the 100 meters, my lords, 100 kilometers along the border, my lords. Now, kindly, my lords, I have placed a map at page 44, my lords. Your lordship will kindly take page 44. Now, this is because this confines and is related to the northeastern states, my lords, and which is very, very peculiar to this part of the country, my lords. Kindly take page 44, my lords. That's the map of the northeast, my lords. Now, your lordship will see we are surrounded by international border on all 4 sides, my lords. We have China at the top, my lords, Bhutan next to China, my lords, and then Bangladesh to the south and Myanmar to the east. So that's the, my lords, peculiar location of the northeast, my lords. Now, why I say this is, my lords, kindly thereafter, my lords, take annexure A2, and I've gone state-wise. Lordship will first have page 45, my lords. Arunachal Pradesh. Now, my lords, will see if we measure from the from the international border, that's China on the north. My lords, your lordship will see at stretches it is 120 kilometers. Somewhere it's 174, 133, 133. That's, my lords, the entire expanse, the left, my lords, the north to south of this particular state. So 100 kilometers, the Forest Conservation Act will not apply. Now, my lords, this is Arunachal Pradesh, my lords.
So, you mean to say that 100 kilometers, if forest conservation act will not,
Yes.
is not applicable?
Yes, my lord.
So you mean to say that at all these 100 kilometers bordering, they'll construct everything?
They will not, my lords. But
Where the strategic importance is there, they'll construct that.
obviously, my lords,
And how
but
can we interfere in this matter where the national
Yes,
security is there?
yes.
And we would say, no, don't allow construction within 100 kilometers. Why, sir?
Let's kindly look at, first, let me finish with the facts. Let's kindly see the next state
Yeah,
at Nagaland, Manoj.
Nagaland,
Yes,
yeah.
lordship will see 117, 137, 134,
Next page is, sir.
46, Manoj.
46 Manipur.
Sorry, Manipur.
Yeah.
Let's that your lordship will see the width from the international border. So 137, 117, 134, and so on and so forth. Then we'll see Meghalaya at 47. This is, Manoj, 84 kilometers, 84,101 at stretches, Manoj. Similarly, Manoj, we'll see Mizoram, Manoj.
Only 60 kilometers.
Yes, and some places 107.
Oh.
Of course, it'll vary, Manoj. This is just to give your lordships an idea, Manoj. Then in Assam at 49, 72, 119, 110.
Is Nagaland.
Sorry, Nagaland, Manoj. 49, 72, 119, 110.
So it is not within the competence of the government.
No, Manoj, that's what I'm submitting, Manoj. I'll come to the reason why I say so, Manoj. One is, Manoj, the impact. The impact of this, Manoj, amendment is that I will not apply the Forest Conservation Act for 100 kilometers from the international border. Of course, Manoj, related to those projects, Manoj. But the moment, Manoj, the moment you say that state development interventions are permitted from the border for a particular distance, Manoj, and we take away the ambit of the act, Manoj, then there is no checks and balances, Manoj. The whole idea, Manoj, the whole idea of a check or a balance, Manoj, now kindly look at, Manoj, and why I say so for the Northeast, Manoj, kindly take the 2003 Act, Manoj, the Forest Rights Act. It negates the entire Forest Rights Act of 2006, Manoj. kindly take the. Because what was sought to be introduced, granted, and undo the injustice that was meted out by the Forest Conservation Act of 1980, was sought to be given back by the Act of 2006, which is the Forest Rights Act. If your lordship will kindly take that for a moment, my lord. And then look at sections 3 and 4.
The scheduled tribes and other traditional forest dwellers recognition of Forest Rights Act of 2006. Not here.
Let's see the other one.
Then, this will be- Hello.
What about these guidelines?
Which one, my lords?
Subsection 3 speaks about certain guidelines.
Please, my lord.
Subsection,
Yes, my lord.
new section 1A, subsection 3.
The exemption provided under subsection 2 shall be subject to such terms and conditions, including the condition of planting trees to to compensate felling of trees undertaken on the lands as the central government may by guidelines specify.
Where are those guidelines?
Because those are not here.
You just show us what are those guidelines? It's whether in those guidelines there is sufficient safeguard is given or not. For that purpose, you have to place it in record by.
We'll place it on record, no problem, my lords. Lords, but I'll do that, no difficulty, my lord. The other thing, my lord, your lordship will consider.
So ultimately, it's a question of what they have said. As is situated within the distance of 100 kilometers along with international border or line of control or line of actual control, as the case may be, proposed to be used for construction of strategic linear project of national importance and concerning national security. But if what these guidelines says,
We'll place the guideline on record.
based on
We'll do that, my lord.
because it's a matter of national security.
Yes, obviously, my
not,
lords.
entered in the light manner.
And we cannot be, my lords, opposed to that entire concept, my lords. Of course, it has to be. But to say, my lords, that the act will not apply. That is what, my lords, is.
Not apply.
Yes,
What they have said, sir.
yes, my lord.
The following categories shall be covered under the provisions of this.
No, my lord, shall not be covered.
Shall not be covered.
Covered.
Only these categories and in relation to this 10 hectares for security related infrastructure.
Yes,
And for campus and paramilitary forces.
Yes,
of
my lord.
campus 5 hectares.
5
Five
acres.
hectares.
Yes, my lord.
They only said this.
Yes, so we can, my lords, have a quarrel with that, my lords, with all fairness.
But
when you
so
put
far
a
as
restriction of 10 and 5.
concerning, strategic linear project of national importance and concerning national security. What projects and what are those guidelines you just?
I will do that, my lords, no difficulty, my lords. Then your lordship may have it some date, I will place that on record at the earliest, my lords.
Learned concept of the commissioner. Place for and granted clarity. Place on record. The guidelines, if any, issued by the central government. As provided under the provisions of section 1A. Of subsection 3 of section 1 capital A of the Forest Conservation Amendment Act 2023. When
My lords, if your lordship will be pleased to have it on the 18th, if it's suitable.
18th, list on 18th.
My lords, your lordship may just say guidelines, if any, my lords, because I am not
If
sure.
any, I
Yes.
already mentioned.
If it is there, of course, we'll place it on record, my lords.
If
If it is
any.
not there, then of course we'll come back. I'm so grateful.
Item 23 and 24.
Lordship, in item 20. Lordship, in item 23, I need to file my affidavit in 24. Lordship, we have already sent it for waiting, Lordship. Lordship may kindly grant some time for filing it, Lordship.
And council appearing for
For all the respondents.
for all the respondents, please. The more time to file. Council to the writ appeal. Full stop. List this writ appeal along with. Another appeal is.
Yes, Lordship. Readable 40 of 2020.
It is listed. Along with 24 of 40 of 2024. After 3 weeks.
Lordship, in item 24, that is readable 40 of 24, there's an interim order, Lordship, that may continue, Lord.
Interim order, if any, to continue in writ appeal number 40 of 2024.
Item 25.
Interim order. It is writ appeal number 40 of 24, which continue till next day.
Lordship.
Lordship, matter pertaining Lordship is a area pensionary benefit Lordship in the year of 1998 Lordship. So here Lordship, the learned single judge Lordship, without contemplative Lordship, my petition was dismissed Lordship. So here Lordship, when the petitioner father, appellant father was terminated in the year of 1994 Lordship, so there was another 6 person was there Lordship. So after punishment Lordship, so other 6 person were entitled to all benefit Lordship. So the appellant father has not been getting any kind of the benefit Lordship. So Lordship, learned single just clear defined Lordship is 86 Lordship. Para number 6 Lordship. Kindly find the page 86. Para number 8.
We are of the view that the matter requires consideration, admit to notice.
Master Lordship.
Item 26.
Met your lordship. In a border road organization, there is an engineering service. That engineering service is a general result engineering for service. There are two set of posts. One is technical and another is non-technical. So for the technical posts are concerned,
Sir, you are not having the requisite qualification as required for diploma holder.
yeah,
Requisite qualification required for a diploma holder, diploma qualification.
no, don't.
That is not, you are not having that.
No. Diploma is not essential here.
Essential.
It is a case of it is a case of promotional post. So far the promotional posts are concerned, diploma is not essential. So far the direct recruitment post is concerned, the diploma is essential. And learned single judge was of the view, that is the problem. Learned single judge of the view, as though it is a promotional post, but there is a provision for direct recruitment. And so far that direct recruitment is concerned, it requires diploma. So you cannot equate yourself with that. That is the basic difference.
It's reasonable 4 weeks.
Item 28.
Item 28, your lordships, I seek my lord's permission to appear through VC.
Okay.
Your lord, here I'm against a CAT order dated 6 March 2024, where my claim of disability pension has been rejected, your lordship, by way of holding that this letter dated 7th August 2001 is a very old letter and much water has flown in the river of Brahmaputra. This is the opinion of learned CAT, your lordship. So
Where is the order of the cabinet?
please, order is at page number 109, your lordships. It starts from page number 109. And relevant paras are relevant page numbers, para 6, page number 115, your lordships. And para 7 is the concluding one. May I be allowed to read, your lordships?
Read.
Para 7, page number 116. Heard Mr. So-and-so, learned counsel for the applicant and Shri learned counsel CGSC for respondent 1, 2, so-and-so, your lordship, and examine documents in record. I agree with the amendment made by Shri so-and-so, learned counsel for the respondent number 5 and 6, that both of them from State Bank of India have no role in the case. Now the OM comes into picture, your lordships. the OM number so and so 7th August 2001 of Department of Pension and Pensions Welfare, Ministry of Personal Public Grievance and Pensions, Government of India, quoted by the Learned Council for the applicant, is a very old and outdated OM. Much water has flown in the river of Brahmaputra and Ganga after that above referred OM was issued, and as per the latest instructions as reflected in the communication of Senior Accountant Officer, Office of the Principal Controller, Defense Accounts Pension under so and so dated 3rd January 2024, now an individual cannot get the benefit of invalid pension as well as benefit of service element of disability pension simultaneously. So here my submissions are at twofold, your lordships. Firstly, your lordships, this OM 2001 is still existing in CCS pension rules. Your lordships may have CCS pension rules revised in 2022. So this circular is very much in existence, your lordships. It cannot be deal that much water has flown or on delay. My lords is much aware about there is judgment of 13th Singh passed by the Supreme Court.
Communication of 3rd of January 2024.
I could not find this communication along with their counter affidavit, your lordships. I'm so sorry. It has been reproduced in this judgment. So, your lordship, there are also one line in this circular in communication. For submission, your lordship, this communication cannot overrule the DOPT circular.
Right, but where is that communication?
Communication is not along with this counter affidavit. I could not get it. It may be they had just handed over before Learned Cat. So right now it is not with me. The only relevant paras have been reproduced in this judgment, your
Where is
lord.
that? Where is that?
Please. It is at 115, your lordships. Para 6. The senior CJC has placed on record a letter dated so and so, dated 3rd January 2024, issued by Sri A.K. Saroj, Senior Accounts Officer, Office of the Principal Controller of Defense Account Pension, Prayagraj, to OIC Legal Cell, which reads as follows. The disability pension consists of two elements. One is disability element and second is service element. Invalid pension and service element of disability pension is granted on the part of service and both are equal to retiring pension. As per Rule 7.1 of CCS Pension Rules 1972, a government servant shall not earn two pensions in the same service or past at the same time or by the same continuous service. Accordingly, individual cannot get benefits of invalid pension as well as benefits of service elements of disability pension simultaneously. However, she may be eligible for disability elements of disability pension if she was invalidated out from service due to disability aggravated by service in terms of Rule 2, 3, and 6 of CCS EOP rules. Rule 6 of CCS EOP rules clearly states that no award shall be made in respect of any inquiry sustained more than 5 years before the date of application. In view of above, the question regarding grant of disability comprising of disability elements does not arise at this belated stage. So here my respectful submission is this, your lordships. Firstly, this is just a communication issued by PCDA, your lordships, who is not the competent authority even. They are relying on...
How much delay was there? Delay was there?
No, there was no delay, your lordship. I got retired in 2009, your lordships, and I have made this application for pension in 2009 itself. August, your lordships may have page number 49 is my application. I retired on 31st May 2009. I made this application for disability pension, page number 49. It dates to 10th August 2009, your lordships. Your lordship may have page 49.
Yeah.
So this is my first application for grant of disability pension. So there is no delay on my part, your lordships.
Application was rejected.
Your lordships, I'm so
When
sorry.
your application was rejected.
My claim was not rejected. Even they have given this PCDA itself have not sanctioned, your lordship, but they have given a bifurcation of amount of disability pension. They have issued a communication along with the details of my disability pension, your lordships. It is only the respondent who came with this letter, your lordships, and the Learned Cat has not taken into consideration my OM 2001.
So what was the occasion for approaching the court in the year 2024, the tribunal?
Because I was waiting for the result of this, your lordships, my applications. These were put on hold.
In the year 2009.
Your Lordships, 2013, I again made an application. Your Lordships may have page number 51.
But ultimately you approached the tribunal 2023 only.
But your Lordships may consider I have been making these representations even in 2014. I again approached. Then 2016, my disability pension application is a page number 55, your Lordships. Then 2016, again, I have made application. So these all are in, these all are before your Lordships that the issue was kept alive. And secondly, your Lordships, Tarseem Singh will
Once in the year,
help me out for the.
excuse me, once in the year 2009, then you first made the application and they have not decided within the reasonable time. Simply because you are giving, filing this representation, successive representation, that will not condone the delay.
Your Lordships, then delay will not come in pension matters. And secondly, your Lordships, I am widow. I have been invalidated out. If your Lordships, as per their communication, if I have been invalidated out from service, then I'm entitled for disability pension. So your Lordship, there is medical document issued by state of Assam, your Lordships.
Notice.
I'm so grateful. I'm grateful, your Lordships.
Item 29 to 31.
My lord, I appeared for the appellant. There was a request made by the other side for adjournment.
There is a latest judgment of this point by the Supreme Court. I have read somewhere. This Ayurvedic doctor said something. Latest judgment.
Ayurvedic is not Ayurvedic matter, my lord. It's a forensic science.
Deputy Director of Forensic Science Laboratory.
That Supreme Court has decided that.
No, my lord, that is item number 34. Lordship is referring to that Ayurvedic doctor.
Yeah, I'm referring to that.
Yes, there is a judgment of the Supreme Court.
Latest.
That is judgment, yes.
Yeah, yeah. No, so, this is item number?
Item 29 to 30.
29 to 31, they already taken adjournment. And in fact, madam, you were there at that time. What I was proposing that since the matter is pending since.
Yes, my lord.
Why don't you, why we admit it?
Yes, admit, post it for hearing. Yes, my lord.
In fact, my lord, what happened, my lord, the persons were selected, my lord, his clients were appointed, and before I was appointed, my lord, there was a stay order. So, my lord, for me, it's not more.
I will admit it and hear
Yes,
yes.
At the earliest.
Okay. Having heard the non-concept of the parties, admit.
I mean, item number 29.
No need to issue notice as parties are, as concept of as the respondents are already represented through respective concepts. Just for the hearing after in the month of November.
Right.
Or
Let it be December, my lord.
in the month of December.
I'm waiting for the state respondents.
Get the service.
Item 32.
32.
I think so.
My lord, all the judgments I have annexed.
But the latest judgment,
The R.A. Bhatt, Gujarat case.
latest in the month or something. In relation to these doctors.
Only last month, my lord.
Last month or.
Last month, I couldn't lay my hands to the judgment, but I have placed on record, my lord, all the judgments until, my lord, we file the appeal. My lord, in fact, there is already a judgment of this honorable court. The learned single judge already said we are entitled to. Now, while implementing the order, my lord, they came up with a very strange logic, and that was somehow, my lord, upheld by the learned single judge. If a lordship
What about that Supreme Court in this modification application or something?
Supreme Court, my lord, there was a review application filed.
What happened in
The review has been rejected.
Rejected?
Yes, yes.
When?
Yes.
It's a matter of 30.
No, my lord, question is.
31st of July 2023 order.
Yes.
Yeah, that has been.
You have annexed those orders, my lord. In fact, if your lordship would kindly come to page 234, that is the judgment of the Supreme Court. Perhaps which was referred by the learned single judge. My lord, this judgment will have no application for the simple reason If your lordships will kindly come to the earlier judgment of the learned single judge at page 158. So that judgment has attained finality. And the operative portion lordships will get at page number 167, where parity of pay was ordered. Now, where is the scope to, my lord, differ from this? Para 15 and 16. A perusal of the order of the division bench of the Uttarakhand High Court passed in WPC number so and so, and order dated passed by the apex court in special leave petition shows that Ayurvedic doctor would have to be treated at par with the allopathic medical officers and dental medical officers under NHM. And as such, there cannot be any discrimination in payment of salary wages between the two. This is further fortified by the fact that the state respondents have taken a conscious decision to give the same scale of pay to the Ayurvedic doctors and allopathic doctors working in the health department under the government of Assam. In view of the reasons stated above, respondents are directed to pay and release the salary of the petitioners at par with the allopathic medical officers of NHM Assam, with effect from the date of filing of the writ petition, that is 18/12/2018. It's a very unqualified order, my lord. Now, while implementing the judgment at page 68, order was passed, which we challenged, which was negated by the learned single judge.
68.
168.
168.
Next, please, my lord.
Yes.
Yes. This is on 21/10/22. In persons of the Honorable Guwahati High Court order in WPC number so and so, and subsequent approval from the government of Assam, the initial remuneration of the medical officer Ayur, doctor engaged under NHM, is hereby revised as follows. Medical officer current initial is 30,500 per month. Revised initial is 40,000 per month. That is from 18/12 from the date of filing of the writ petition until 31/3/2019. That will be 40,000 per month. And my lord, from 1/4/19 onwards, it will be 50,000 per month. The existing medical officer Ayur under NHM are hereby eligible to draw revised initial remuneration for the corresponding period as above from 18/12/18 to 31/3/19 and from 1/4/19 onwards in case of drawing lesser remuneration per month. But where is the scope to make this distinction between? Honorable Court's direction is very clear. With effect from 18/12/18, at par we must be paid.
Now, what distinction they have made?
My lord, what they have done, initially we were receiving 30,500.
They have announced it up
To 40,000 with effect from 18/12 to 31/3/19.
Fine.
Then from 1/4 onwards, 50,000 per month.
Fine.
But our counterpart allopathics were getting much more.
50, more than 50.
Yes, yes.
How is CP?
In this regard, may I submit my lordship will grant me at least 2 weeks time. Let me file one affidavit because affidavit was not filed in the before the learned single judge. Clarify. Yes.
Now, learned single judge, my lord, relying upon P.A. Bhatt's case, where they say that the role is not same, therefore this disparity can exist.
In relation to retirement age or something.
My lord, there are two sets of cases, one regarding age of retirement, other is regarding pay parity. My lord, I have given annexed all the judgments of the Supreme Court here.
Where is the order of the learned single judge?
Yes. Page, it starts at 207, my lord. And if your lordship would kindly come to 211. Para 8 onwards. I have heard the learned counsel for the parties and given my anxious consideration to the matter. From the judgment passed by the Supreme Court in the case of Dr. P.A. Bhatt, wherein it is categorically observed that Ayurvedic doctors and allopathic doctors discharge diverse functions and are not performing equal work, and as such would not be entitled to equal pay. The issue therefore pertaining to grant of pay on the principle of equal pay for equal work therefore stands concluded in view of the judgment. My lord, even if P.A. Bhatt judgment is a good law, my lord, in view of the fact that the order of the learned single judge has attained finality, PF will not come in the way. Lordship knows those line of decisions. That judgment will have to be interfered with. That has not been done.
And, I think there is a latest judgment that I forgot whether it's in relation to retirement age or pay parity. Some judgment is there.
Latest is
No.
my lord the Gujarat one. My lord, pay parity is the latest one.
No.
Retirement-
Gujarat, no, by the Supreme Court.
Yes, by
Yes.
by the Supreme Court, by my lord, that the appellant was the state of Gujarat regarding pay.
Now,
parity,
my
which is
lord,
the- which is only in the field as on date.
my lord, there is another judgment of the Supreme Court that we have annexed at page 253. Please come to page 258. 258.
Yes.
Please come to para 23.
Yeah.
The common contention of the appellant before us is that classification of Ayush doctors and doctors under CHS in different categories is reasonable and permissible in law. This, however, does not appeal to us, and we are inclined to agree with the findings of the Tribunal and Delhi High Court that classification is discriminatory and unreasonable since doctors under both segments are performing the same function of treating and healing their patients. The only difference is that Ayush doctors are using indigenous system of medicine like Ayurveda, Unani, etc. And Central Health Service doctors are using allopathy for tending to their patients. In our understanding, mode of treatment by itself under prevalent scheme of things does not qualify as an intelligible difference here. Therefore, such unreasonable classification and discrimination based on would surely be inconsistent with Article 14 of the Constitution. The order of the Ayush Ministry extending age of superannuation to 65 years also endorses such a view. The extension is in tune with the notification of the Ministry of Health, Family, etc. Even government of Assam in the health department, my lord, they are giving same pay that we have annexed.
Finally,
Fine.
I'm contemplating for the. How much time?
Lordship, please proceed after 3 weeks. And
3 weeks time to file on Tuesday.
My lord, Lordship may admit this petition, meanwhile it can be fixed for hearing, let them file them whatever they, yes.
3 weeks, and this matter, 3 weeks for final hearing at.
In month of December, my lord.
At admission stage in
Yeah.
December.
Deeply.
God bless.
Item 34.
May I please, your lordship, on last occasion, the private respondent has strict time to take file response.
Lordship, give us one more chance, Lordship, last chance.
Last opportunity is granted to the consent for the respondent number 5.
Yes, my lord.
Respondent number 5 to file counsel to the
10 days time. 10 days time.
last opportunity of 10 days is granted to the consent for the respondent to file counsel to the list of 10 days.
Review of placement.
Item 36. Item 36.
List of very.
For hearing, item 37.
Lord, in this case, my lord, we have challenged the judgment passed by the tribunal, Central Administrative Tribunal, Guwahati bench. But before that, my lord, although of course it is not the pleading of the case, my lord, matter relates to, my lord, sexual harassment at workplace.
Section?
Harassment at workplace. That is institution, petitioner is a teacher working in KBS, Bank Dubi, Shiliguri, which is, my lord, at the time of filing the petition, my lord, Shiliguri was within the jurisdiction of the regional office Guwahati. Therefore, the petition is said to be maintainable. In the meantime, my lord, Lordship is quite aware that Supreme Court in Vishaka's case, Supreme Court has laid down certain guidelines saying that, my lord, since there is no any enactment, therefore, till any enactment is made, any act is made by the parliament, then the guideline will have the, my lord, force. And as per the guideline, my lord, guideline provided two types of inquiry. One is preliminary inquiry and the summary inquiry. And summary inquiry is the basis to take a decision whether it is to be, inquiry is to be, regular inquiry is to be dispensed with.
Who is for the other side? You are for?
Respond number 5, Lordship.
What about the Union of India? Who is appealing for the Union of India?
Therefore, my lord, if I, my lord, raise a question that in terms of the Supreme Court decision, the guideline will remain forced till any enactment is made. In the meantime, my lord, in 2013, Sexual Harassment of Women Workplace, my lord, Prevention, Prohibition and Redressal Act 2013, my lord, was enacted. And my lord, so far as the petitioner is concerned, present case is concerned, matter relates to an occurrence which occurred in 2014. Therefore, my lord, in terms of sexual, my lord, para 16 of the Vishaka's case, my lord, whatever guideline was framed, that lost its force. Therefore, you cannot initiate a proceeding as per the guidelines. You have to initiate the proceeding as per this act. But if it is acceptable, their argument is, if acceptable, then entire proceeding will be nullity without jurisdiction. And in that case, if your lordship accept my contention or submission, then I need not go into the merit of the case.
How can we, at this stage, how can we say this? Until and unless we argue it will ponder over.
My lord,
Then only will,
no, that's why, my lord, whether I am to address only on the question of maintainability. Of course, it is not a part of the proceedings, my lord. That question was not
it is
raised.
not a part of the pleading before the tribunal.
No, my lord. But even then, my lord, since it is a question of law, it, my lord, touches the very root of the proceeding, my lord. Jurisdiction.
That, once you have gone through the inquiry without raising any question.
That's right.
Now you are raising that this has to be followed, sir. How can we permit you, sir?
My lord, lordship will appreciate a proceeding initiated without any authority. Is it not a question of law?
It is a question of law, but you have submitted to the jurisdiction of that authority without raising any question that you are not competent to do so.
That's right. But there is a lapse on the part of the, my lord, petitioner. I say, I don't want to blame the advocate. Of course, my lord.
That's no question of blaming the advocate, but things raising, but this point you have.
There is a, my lord, that was no pleading as such, my lord.
Then how can we consider it, sir?
Then, my lord, if you now lordship, only option there is open to me is to argue the matter on marriage. My lord, then, my lord, of course, I'll be grateful to your lordship, my lord, because I prepared the case on that point regarding maintainability of the process.
So on that point also, as well as on merits also.
My lord.
After a week.
My lord.
After a week. Argue on the merit also.
My lord.
Argue on this point also and merit also. Whether you can raise such point at this belated stage that there is no pleadings or not, if any law is there, you please submit us.
My lord.
You are open to consider that.
My lord.
Yes.
Item 38.
My lord, lordship fix them around 10th.
Whatever the date.
My lord, after 4, my lord, any date after 4.
You suggest the date.
My lord.
Then
Lordship, in this item, I'm praying for some accommodation for the day.
which item number?
Item number 38, Lordship. Senior advocate is Dr.
Adjourn.
Hearing that.
Adjourn.
Lordship.
Matter is adjourned.
Item 39.
Lordship, can a date be fixed and if it is convenient to the court?
Don't tell you are asking for this adjournment, adjourn for 4 weeks. Then you
Lordship,
told us
only
to
for the
say
day I was
4 weeks, that's all.
deeply upset.
Yes. Who is for the appellant? N.K. Kalita.
Lost.
Nothing. I'm present, adjourn. Yes.
Item 41.
Lordship, my seniors, the legs in other court, so matter may fix on 25th. God bless.